Baldwin walks in and says, "Hold my kombucha." And then we see another round of Stellar 4D chess. I have no idea whether or not he actually drinks kombucha grok. Made it seem like Baldwin is more of a celery juice guy, but you get what I mean. Anyway, I'm talking about Blake Lively's motion to dismiss and Justin Baldwin's opposition to her motion to dismiss, which he recently filed on April 3rd. In my last video on Lively's motion to dismiss, I talked about the legal privileges that she asserts in her plea are only available to Lively to assert in the first place. And that's really important, because in Baldwin's opposition, Baldoni's new vicarious liability argument to Lively's motion to dismiss, we see some really brilliant wizardry by Baldon's lawyers. And by that I mean we see a new argument by Team Baldwin about Lively's liability here. It's called vicarious liability. Baldwin's legal team says that Blake Lively is not just liable for her own statements that she herself made. They say she's also vicariously liable for the liability of her agents, namely the other defendants in the lawsuit. And that's huge, because it means no matter what the judge decides about these other privileges, if he decides that Baldwin can proceed with this theory of vicarious liability against Lively, it means Baldwin can hold Lively responsible for the allegedly defamatory statements by all of these other individuals. So in other words, let's hypothetically say that Judge Lyman says none of the statements in the CRD complaint can serve as the basis of defamation liability. With vicarious liability alleged, that doesn't mean that Lively gets to dismiss the defamation claim against her entirely. That's because she still has to worry about all of these other statements that these other people made allegedly on her behalf as her agents. But before we get too far ahead of ourselves, let me first explain what vicarious liability is, and a little bit of what's required in order to assert it normally. The default rule is no one walking this earth is legally responsible for the acts of anyone else. What someone else does with their free will is up to them. And even if I have a very close relationship with them, I'm not legally responsible for what they themselves did. However, there are some exceptions to that rule. Agency is one of them. If someone hires another person to work for them, the person that is hiring them is the principal, and the person who's been hired is the agent. If the agent is performing their job duties for the principal, and just as part of their job they do something that harms a third party, there is a possibility that the third party could hold not just the agent responsible, but also the principal. So think of it like a trucker that's driving for a shipping company. They're driving across the country and they don't do anything necessarily against company policy like drinking and driving or something, but they get a little tired because they're on a tight schedule, and they've been forced to give up some needed sleep. And as a result, they get into an auto collision. The people in the other car probably sue the driver and the shipping company because the driver was working for the benefit of the shipping company when he collided with the other car. So what Baldwin is alleging here is that Sloan and the Sloan parties are agents of Blake Lively, both literally and legally. They were hired precisely to be her personal relations agents and to talk to the media on her behalf and for her benefit, and they made statements to the press on Lively's behalf, both on and off the record, that Baldoni says are defamatory. Honestly, that's a pretty solid argument for defamation agency. It's also notable that it's the same logical reasoning that Lively herself is using to sue Baldwin and the other wafer parties for defamation for statements made by Brian Friedman to the media. That was one of the things that she added to her claims when she amended her complaint back in February, and on all sides, both by Baldwin and by Lively, this is all pretty solid reasoning for asserting an agency theory of liability. Now, Baldwin also says that Lively should be vicariously liable for the statements her husband Ryan Reynolds made to WME. The alleged Baldwin is a sexo acting as an agent of Lively when he allegedly made those statements. So in my opinion, the reasoning here fits very well. And best of all, for Baldoni, it provides essentially a backup theory of liability for successfully suing Lively for defamation in the event that all of her direct statements get tossed out of this lawsuit. And so I really don't see how she gets kicked out of this defamation claim. Now, the only argument that she might have some success on at this particular stage is the fact that this is a new argument. By Baldwin, they have not made this argument before filing this opposition. They do make the factual allegations that these various statements were made and that they were made on her behalf. But they don't assert the legal theory that she made these statements through these people as her agents. But I'm going to talk more about that specifically in a bit. So watch until the end for more of my thoughts on what I think will happen on this particular issue. Trust me, I think you might find it pretty interesting anyway. California sexual harassment claim privilege. So now Baldoni also specifically addresses the legal privilege arguments that Lively makes in her motion to dismiss. And even in those arguments, we see some very good lawyering that shifts the analysis on the issue, in my opinion, in favor of Baldoni. So let's start really quick with the so-called California sexual harassment claim privilege, as Lively calls it. This is California Civil Code Section 47. This basically says that anyone who makes a claim of sexual harassment in the workplace without malice is protected from liability, basically. That means if someone made a good faith claim, they can't be held liable for defamation. Now, I did talk about this in the first video, but there are some things that I really should have clarified a bit better. What I pointed out in the first video on this topic was that an essential piece of this statute is that to claim the privilege, the sexual harassment claim needed to be made without malice. And I said, well, Baldoni alleged actual malice as he needed to as a public figure. And because of that, this really can't be dismissed at this stage with this particular argument. Let me explain that a little bit better here. Remember that Belden has alleged his defamation claim. And so if all of this goes to trial, he's going to have the burden of proving every single element of defamation. That includes the element of actual malice, his allegation, that Lively knew that what she was saying was false, or that she was at the very least reckless as to the truth or falsity of the statement. Lively, however, has just asserted this privilege as what we would call an affirmative defense. An affirmative defense is more than just a regular defense. A regular defense to defamation would be something that basically attacks the plaintiff's ability to prove one or more of the elements that they need to prove in order to win on the claim. So an example of these defenses argue that she should not be held liable for the statements she made without malice, which is a question for the jury to decide. The issue of law involves legal standards and whether the law allows someone to hold another person responsible for something. The trialer of law or judge answers these questions. The issue of fact involves weighing one side's evidence against another side's, which is usually answered by a trier of fact. In cases where a jury trial has been requested, the trier of fact is the jury, and no judge wants to take away a case from a trier of fact, especially a jury.
So beautiful to watch.
Lively argues that all of her alleged statements are covered by the litigation privilege because they come from the CRD complaint, which she submitted to the California Civil Rights Division to obtain the right to sue notice.
That's it. No.
Balden's opposition to Lively's assertion of the litigation privilege and fair report privilege shifts the analysis in his favor. He argues that pre-litigation communications are only covered by the litigation privilege if they were made about litigation that was contemplated in good faith and under serious consideration. This means that the defamation claim under this argument may still survive until a jury can look at it under the best of Lively's arguments. Baldon also points out that the CRD complaint is not where the statements that gave rise to her defamation claims were made. They argue that the communication must function as a necessary or useful step in the litigation process and serve its purposes in order for it to be covered by the litigation privilege. If the allegedly defamatory statements were actually coming from the CRD complaint, Lively would be better able to assert the litigation privilege. The case between Blake Lively and Justin Baldoni has been a contentious one, with the Belden side alleging that Lively Reynolds and the Sloan parties started working with the NYT months before the CRD complaint was filed. The crux of the FAC is that Lively worked closely with the NYT throughout the fall of 2024, feeding its reporters defamatory statements and coordinating closely to ensure the end result would amount to a kill shot to the wafer parties' reputations and careers. This had nothing to do with any ongoing judicial proceeding. The communications between Lively and her team and the press are more involved than what is typically covered by the fair report privilege. To side with Lively, it is necessary to know the actual truth of what happened behind the scenes with these communications. The evidence is an issue of fact for the jury to decide, which means it is not likely to be dismissed at this stage. Baldon has responded to Lively's arguments with strong counter-arguments, and Lively has made Baldon's case even stronger. He has asserted that Lively is also vicariously liable for the statements that the other defendants made, a new assertion that has not been heard from Baldoni and the Wayfair parties before this opposition. This new theory of liability needs to be specifically pled in the complaint for the plaintiff to pursue it. The judge is likely going to tell Baldoni and the Wayfarer parties that they need to amend their complaint again to add that allegation. This could lead to Baldon filing a second amended complaint alleging more basis for liability against Blake Lively, potentially strengthening their claims and potentially allowing them to allege even more.